song that's sort of like a big band tune at a rock concert. But I do think that the case remains theoretically, even philosophically interesting, and perhaps Ms. Kennedy will have some response to the comments that I would make about it. I'll begin this way. The presumption of our Garfield Center for Study of Public Leadership is that it is possible to raise issues that are serious, that are issues about which there is sharp partisan divide, and that it's possible to raise those issues and discuss them in a way that is not marred by partisan rancor, not to speak of deliberate partisan distortion. This is a proposition that is beleaguered today, but we stick to it rather doggedly. And if that proposition is true, then it ought to be the case that people who are not in opposing camps, and Professor Clark Neary and I are not really in opposing camps, but it ought to be possible for people who are not in opposing camps still to observe important points of divergence so as to bring light to these political issues. At least I'm compelled to hope that that's true. Since I am, I confess, as the Garfield Institute people like to say, in the interest of full disclosure, I confess that I'm inclined to think that in the Heller case, it was the court and Justice Scalia and Clark Neary that did have the better of the argument. I thought this even before the case. Just as a matter of grammar, it seemed to me, and still does seem to me, that the Second Amendment, like the other examples of the Bill of Rights, identifies, that is to say, vests a personal right, and that the preamble's reference to the well-regulated militia does not limit the scope of that right, not in the sense of being a limitation on to whom it applies, or a limitation on the purpose for which the right might be exercised. So, for a kind of hypothetical example, similar example, if it were the case that the First Amendment's protection of freedom of speech in the press were to begin with such words as indicate the importance of free speech to Republican self-government, it would not be the case that speech that fails to serve that purpose would not enjoy the protection of the First Amendment. Nobody would hold that. Of course, the First Amendment doesn't begin with such a preamble. The Second Amendment does, but if the First Amendment began with such a preamble, it would no more modify the scope of the right than it is necessary to conclude that the actual preamble of the Second Amendment does so. However, having said that, I do think that we are fortunate with regard to this case that the dissent, and in particular, there are really two dissents, one by Breyer and one by Justice Stevens, but I think the dissent of Justice Stevens is learned, powerful enough to require the careful and close reasoning of his opponents, like Mr. Neely and Justice Scalia. John Paul Stevens writes in good faith. Faith in what? Faith in three propositions, also beleaguered ones, at least in certain quarters. That the Constitution has a meaning, and it is the meaning of its words as intended by its authors. Secondly, that that meaning is discernible. And thirdly, that it's authoritative. Stevens is a constitutionalist, even an originalist. Now, these propositions are by no means universally accepted today. In some quarters, they are repudiated with a kind of wry smile of contempt. But I would submit that such contempt is misplaced. Their repudiation, the repudiation of the three propositions in question, would make genuine discourse impossible, as well as lawful government. That's just an assertion. The proof of it would, of course, have to lie in the pudding, as people say. Stevens' reading of the Second Amendment is nowhere stated more clearly than it is in the conclusion, from which I can read. The majority's exegesis today has utterly failed to establish that as a matter of text or history, the right to establish, the right of law-abiding, responsible citizens to use arms in defense of hearth and home is elevated above all other interests by the Second Amendment. Until today, it has been understood that legislatures may regulate the civilian use and misuse of firearms so long as they do not interfere with the preservation of a well-regulated militia. So, under the weight of that conclusion, I have a number of questions regarding the court's argument, about 5 questions. Beginning with the most important one. Why is there a preamble to the Second Amendment at all? It is a unique feature of the Bill of Rights. Is there something about the Second Amendment that especially needs a preamble in order for us to understand the meaning and therefore the limit of its scope? I think it could be argued, it seems to me that this is what Justice Stevens has in mind. It could be argued that a gun, unlike speech, is essentially an instrument of violent force. As such, it is in tension with the primary interest of government, to preserve the public peace. Now, to be sure, there are uses of guns that do not threaten the public peace, at least directly, like, hunting, target shooting, and so on. But it is also the case that our framers attached importance to the right to keep and bear arms, in large part because they saw an armed populace as a potential check against usurpacious tyranny. Now, to be sure, no sensible person could think that the Second Amendment implies a vested legal right of armed resistance to the government. There could be no such legal right, a right to revolution, so to speak. Scalia knows that. Stevens knows that he knows it. Still, many of the framers also held that there is a natural, unalienable right, not one that we derive by way of having been vested in us from government, but an unalienable right that we have by nature to insurrection and revolution. And they did see the right to keep and bear arms as being important, in part at least, so as to make the threat of forceful resistance to tyrannous government a real and effective threat. But if that's an important consideration, then it carries with it a corollary question. How is the right to revolution, perhaps indirectly recognized by the legal right to keep and bear arms, to keep and bear the means to such revolution, not dangerous to lawful government, and is armed violence? This is the danger that I submit John Paul Stevens thinks the framers were concerned with, and which required the preamble. That is to say, the framers, those arguing for the Bill of Rights as a condition for ratification, presumed that the danger of tyranny came from the national government. It's beyond peradventure that the Bill of Rights was originally a check on congressional power and only upon congressional power. As Mr. Neely mentioned in his opening remarks, it was not until quite recently, 2010, in Chicago, McDonald's v. Chicago, that the right to keep and bear arms was extended as a limitation on state power as well as national power. Especially, it is the case that the national governments posing the danger of being tyrannical and usurpacious would be especially severe if the national government were equipped with a regular professional army. So the framers, for them, the form of armed resistance to tyranny, which was still in the service of legitimate governmental authority, was for there to be no such professional standing army, but instead an armed civilian force, well organized under state authority. This consideration provides the morally legitimating context for the right to keep and bear arms. And it's the thinking that I suggest causes Justice Stevens to read the preamble as having the relevance he thinks it does to the scope of the amendment. So, if those remarks make any sense, in their vein, I would ask several questions. The first one being, why, from Mr. Neely's point of view, is there a preamble to the Second Amendment at all?
So, in order to make sense of the preamble, we have to ask ourselves a few questions, and I think before one attaches too much significance to it, one needs to ask, and be candid with oneself, does anybody, for example, know how common preambles of this kind were of the founding era? And the answer is quite common. There was a mention before about, well, what if the First Amendment contained a preamble? Well, guess what? That's actually not completely hypothetical. The Constitution of the State of Rhode Island reads as follows, or the 1842 version reads as follows: the liberty of the press being essential to the security of freedom in this state, any person may publish his sentiments on any subject. Very, very similar in terms of its construction to the Second Amendment. And I'll spare you a recitation, but there's a wonderful article by Professor Eugene Bollock called The Commonplace Second Amendment, in which he documents dozens, if not hundreds, of similar constitutional provisions from the same time frame that had similar preambles. Not one of them, not a single one, has ever been construed to significantly influence the interpretation of the operative clause that follows. And guess what? There is another preambular provision in the U.S. Constitution. It's in Article 1, Section 8, and it's the provision that says that to promote the progress of science and the useful arts, Congress shall have the power to issue patents and trademarks. That is another preambular provision, and it also has never been construed to in any way influence the scope of what follows. In other words, it has never been held that Congress can only issue a patent or a copyright. I'm sorry, it's the patent and copyright provision. But it's never been held that Congress can only issue a patent or a copyright that will in fact promote the progress of science and the useful arts. So the idea that the preamble, or the preambular phrase of the Second Amendment would alone, among all of the preambular provisions that were familiar during the founding era, have tremendous interpretive significance when not a single other preambular provision from this era has ever been given any meaningful significance, is very difficult for me to embrace. No one yet has come up with I think, a very persuasive or compelling explanation for why the preambular provision of the Second Amendment alone, among all of the dozens or hundreds of other similar provisions that were familiar during the founding era, would be given this incredibly substantive effect on the operative provision that comes next, when no other similar provision of the same era has ever been interpreted that way. Going to the heart of the question, why does the Second Amendment have a preamble? You have to ask yourself another question, which is, do you know where else in the Constitution they speak of the militia? And I would guess with most people the answer is no. But the answer is Article 1, Section 8, Clause 16, which gives Congress various powers over the militia, which includes militia that are armed by the states, but over which Congress has authority when they are called into service. And this gave rise to very strong and fervent disagreement between the Federalists, who were primarily responsible for drafting the Constitution and for advocating its ratification, and the anti-federalists who were strongly opposed to the ratification of the Constitution because they were worried that the creation of a national government presented a risk of tyranny. And one of the biggest points of disagreement between the Federalists and the Anti-Federalists was over allocation of control over the militia forces as between the national government, or Congress, and the state governments. And one of the things that the Anti-Federalists felt very strongly about is that they, during the amendment process, which followed 2 years after the ratification of the Constitution, they wanted that entire provision rewritten to give the states more authority over the militia forces than the original Constitution had done. James Madison and the other Federalists were staunchly opposed to that proposal. They did not want to rewrite Article 1, Section 8, Clause 16, that gives Congress primary authority over the state militias. And so what they did instead was it included some language in the Second Amendment to make clear that one of the reasons, and let me stress this, one of the reasons why the Bill of Rights recognizes the right to keep and bear arms was to underscore the ability of individuals within a state to arm themselves, very much the same way the colonists armed themselves to resist the tyranny of the British, and to underscore the fact that residents of the various states had a like authority and a right, indeed a natural right, to arm themselves, and that one of the reasons for that right, but by no means the only reason why that right should be recognized in the Constitution, was to make clear that ordinary citizens of the states had the authority and the right to arm themselves to resist tyranny from the national government should it arise. And I want to conclude with one final point, which is this. Everybody during the founding era, at least that anybody who went on record about this, made clear that they did not understand the Constitution or the Bill of Rights as conferring rights on individuals. The only thing a Bill of Rights can do, according to the founding generation, and I believe Scalia agrees with this, and I agree with this, is to acknowledge to acknowledge an existing natural right that people have. And think about this as a thought experiment. The U.S. Constitution went into effect in 1789 with no Bill of Rights. We didn't get a Bill of Rights until 2 years later. Does that mean that for the first 2 years of this country's existence, the Congress had complete authority to suppress speech, shut down newspapers, and board up churches, simply because there was no First Amendment to recognize those rights to free speech and free exercise of religion? I don't think very many people think that Congress did have that authority, or that it would have had a right or the authority, the legitimate authority, to infringe on the natural right of free expression and free exercise of religion, simply because those rights had not yet been expressly recognized by the Constitution. Those rights exist completely independently from any textual recognition. Whether the Constitution does or does not explicitly recognize a right of free speech, it nevertheless exists, and every citizen of a free country possesses the natural right to free expression, regardless of whether the Constitution happens to recognize it or not. And I believe the framers believed, and I think Justice Scalia and the majority justices in Heller believed, and I believe, that the same is true of the right of armed self-defense. The right exists. It predates the Constitution. It predated the Constitution. It predated the Bill of Rights. And nothing in the Second Amendment was in any way designed to constrain or limit the pre-existing natural right of armed self-defense. Regardless of what the so-called militia provision may or may not say, and what its significance may not be, the operative provision of the Second Amendment tracks the pre-existing natural right of armed self-defense perfectly. The right of the people to keep and bear arms shall not be infringed.
Well, Mr. Beatty has said some things that are matters not entirely of constitutional law, but political philosophy, some of which I agree with and some of which I don't. I think it probably would not serve our best purposes to engage in the kind of debate about matters of political philosophy that would be invited by those remarks, it would be a very long debate. I'll just say, so as not to be accused of taking a big pot shot, that I do think, Clark, that your statement that the Constitution does not confer any rights, but recognizes rights that we hold as a matter of natural right, is not true. It seems to me to involve a conflation between legally vested rights and natural rights. Natural rights are said by the Declaration of Independence to be unalienable. Legally vested rights are clearly alienable and limitable constitutionally and by one's legitimate authority. I could give an illustration of another element of the Bill of Rights. The right to freedom of religion would, I presume, Mr. Mealing would hold to be of the same status as the right to keep and bear arms. And therefore, he would call it a right that is unyielded to government, and which we have by nature. And yet it was widely held that even under the Constitution as amended by the Bill of Rights, states retained substantial powers over religion, even to the point of establishing churches and requiring their attendance as a matter of law. This was not considered illegal or unconstitutional or a violation of natural right. But
let me,
as I said,
if I
that's
may,
a long question.
let me respond briefly. I think you're right. I don't think we want to go off on a sort of sidetrack of political philosophy. Let me bring it back to constitutional doctrine. There's a United States Supreme Court case called U.S. v. Cruikshank from 1876, in which the court unanimously said or stated that the Bill of Rights and the Constitution does not create rights, it acknowledges rights. Justice Scalia repeated that language in the Heller case, and no justice in the dissent disagreed with that statement. So it may or may not be true as a matter of political theory, but it is the position of the U.S. Supreme Court, and has been the position of the U.S. Supreme Court for nearly 150 years, that the rights listed in the Bill of Rights and elsewhere in the Constitution acknowledge pre-existing rights, but do not create or confer those rights. So it may or may not be accurate as a matter of political theory, but it has been a bedrock principle of constitutional law for almost 150 years.
Is it not the case, though, Clark, that Cruikshank is the precedent that was overruled by McDonald v. Chicago, and that therefore prior to the McDonald precedent under Cruikshank, it was, the court said, Congress that was restrained from limiting gun rights by the Second Amendment, but not the states?
Yes, but that doesn't go to the question of whether what the status, according to the U.S. Supreme Court, is of these rights that we've been discussing, and whether they are, on the one hand, pre-existing and natural, which is my position, and I believe the Supreme Court's position, or on the other hand, they are essentially positive rights, or not positive rights, but they are rights that are effectively conferred by the Constitution and only sort of exist by virtue of being acknowledged in the Constitution. Again, I don't know that it's fruitful to get too bogged down in this, but I want to make clear that what I am conveying is not sort of an idiosyncratic personal belief, but it really is bedrock constitutional doctrine that's been acknowledged by the Supreme Court, that the Bill of Rights does not create rights, it acknowledges them.
All right. The other questions that I have are really just by way of asking for clarification of some implications of the position that you staked out, and which I reiterate share fundamentally. But let me ask this. Even under the court's interpretation of the relevance and the meaning of the preamble, Scalia's interpretation, would you hold that the amendment protects people's keeping and bearing arms of a sort that would be in fact useless in a contemporary militia? um, if the purpose of the militia is to resist tyranny, and under modern circumstances, the tyrant would be armed with tanks and howitzers and so on, would hunting rifles be of any use? And therefore, would they fall within the meaning of the amendment?
Yes, absolutely. Every object which is capable of being used as a weapon has potential military use. And I say that not lightly, but we have been involved in many conflicts as a country where we had vastly greater military technology and weapons than our opponents. And where nevertheless we have been fought to a stalemate, and in some cases people would even argue to a loss, by soldiers who went into the field with far less sophisticated weaponry than our troops possessed. You do not need to have tanks and fighter aircraft, let alone nuclear weapons, in order to successfully resist a tyrannical force. You just have to be able to inflict upon that force more casualties and more pain and more damage than they are prepared to withstand. And that can absolutely be done by any object that is capable of being used as a weapon, even a stick or a rock. Of course, you'd rather not go into battle with a highly technologically sophisticated army with relatively primitive weapons, but the point is not always necessarily to win, it's to make the cost of victory unacceptable to your foe. And I would note that in 2016, the U.S. Supreme Court, in a per curiam, meaning a very abbreviated opinion, summarily reversed a decision by the Massachusetts Supreme Judicial Court that held that a state stun gun ban presented no constitutional concerns because stun guns, according to the Massachusetts Supreme Court, had no military application. And the Supreme Court, in a per curiam unanimous opinion, reversed that decision and made clear to the Massachusetts Supreme Court that that was an incorrect approach to the Second Amendment. And Justice Alito wrote a very impassioned concurring opinion in which he made very clear that the Second Amendment speaks in terms of arms, and that it is not an appropriate way to interpret that term by simply saying, well, would this particular weapon enable you to defeat a modern military force? So we do know that the Supreme Court has held that something like a stun gun, which really doesn't seem to have particular military application, is eligible for, probably, depending on how you read this opinion, it's called Paitano versus Massachusetts from 2016, that a stun gun is, according to the U.S. Supreme Court, covered by the Second Amendment. So this idea that to be protected by the Second Amendment, a particular weapon has to have obvious and perhaps even overwhelmingly useful military application is not a proposition that has been embraced by the Supreme Court, and in fact has been specifically rejected by the Supreme Court.
Thank you. In some states, I haven't researched this, I'm just told, there were laws that not only, that required able-bodied citizens not only to keep in their arms, but to maintain them in good working order. Does that fact lend support for Stephen's overall argument that the right under the Second Amendment should be understood as a corollary of a state-run militia?
No, not in my judgment. I don't think that first of all, there was much of a time, obviously, and there were reasons why, for example, there was a federal law that required all able-bodied men between the ages of 18 and 45, enrolled them as members of the United States militia. It required them to possess certain weapons and accoutrements that would be of use in combat. So it was both the federal government and the states that had laws that required people to maintain various arms. But to me, that doesn't particularly speak to the scope or the substance of the individual right, if there is one, and of course I do believe there is, of the individual right to own a gun, any more than a law requiring people to achieve a certain amount of literacy would shed any particular light on the substance of the First Amendment right of free speech. I just don't see how the government's, a piece of positive legislation requiring people to act in a particular way, to achieve a particular skill, or to maintain a particular set of equipment, speaks to the scope or the substance of an individual right that may have some, an analogy, or that may be similar in subject matter to those positive requirements. But I don't see those. Anachronistic requirements that people equip themselves in a particular way as shedding light on the substance of the Second Amendment, of the individual right to own a gun and the Second Amendment.